Dr. Anurag Batra and the distinguished sisters and brothers from the corporate and legal world present here. While I was lighting the lamp, I was just thinking of the Sanskrit hymn, Asadoma Sadgamaya, Tamasoma Jyotigamaya, Mrityoma Amritangamaya. One wonders if we were to write on it now, it would have been just the other way. It's a tough competition now to run from Sat to Asat, Tamas, light to darkness, and what you call life to death. Everywhere we find a sort of a culture of death, culture of untruth, culture of darkness. Very difficult to find culture of light, culture of life, culture of truth. And I'm sure this new endeavor by the business world under the leadership of Dr. Batra will be a new step to introduce a counterculture of light, truth, and life. Because it is a corporate world, everything is corporate now. One could not have thought of corporate law firms maybe 10 years back, or maybe 10 to 15 years back. And mind you, the legal services is exempted from GST. Maybe one of the two services which has been exempted from GST is legal services. No lawyer is to pay GST on the service he renders. Because it has never been thought of a business. It has always been recognized as a service and a different and distinguished type of service as well. It is into that service now the corporate culture has stepped in. So I happened to meet a very honest person working in Punjab and Haryana. Which sector I will not tell you. Since he did not yield to the pressures from a different world altogether, he was trapped. Naturally, he had to take recourse to the legal services, and by the time he reached Supreme Court, he had become one of the most corrupt persons in the society. I asked him, because he was known for his integrity. He told me, sir, for reaching up to Supreme Court, I had to spend almost 56 lakhs of rupees from the domestic inquiry to the labor court, to the High Court, and to the Supreme Court. Where do I find my money? In the whole service in my life, I get about maybe 20 lakhs if I commute everything. But where do I find money? The only way to find money to pay to the lawyers is to be in the trend of getting money to pay the money. I was honest. I thought I was living in an honest world, and honesty will have its rewards. But I found I am a foolish person. I sold many things to sustain my livelihood and to fight for truth. But finally, I had to succumb because I realized I had to pay the lawyers. And nobody knows the corporate world in the legal arena, how much you may have to spare for the services that corporate sector or the legal sector renders. One reason for the service sector in the country having become corrupt is because of the enormous fees they had to pay to the lawyers in case they had a service problem. I'm sure no lawyer would have take charges with me for having said this. It's a fact. And if you speak to the lawyers, they say, well, we are in a service sector, but we also need to be either swimming or singing, but we don't want to sing. We want to swing. if you want to sin, you have to be in the forefront. That's so they have their own answer also. I just gave this disturbing introduction because it has slowly from the service sector, this legal sector or legal service is also taken the shape of a corporate culture. And that's why I find the new initiative of the legal, BEW legal, of showcasing the legal services of the corporate firms and the non-corporate legal services as well. Well, what's a legal service? See, in good old days, many of the corporates who might be sitting here would know that you needed to have only a casual consultation with a lawyer in case you had a problem. As times grew, then you needed to have a law officer in your corporate sector. And now you need to have a legal branch in any corporate or industrial sector. So I do my arbitrations now after my retirement. I do my mediation also, I do legal opinion consultation also. So many of the arbitrations, when I meet the corporates or the industries, they say, we have a legal team. This is the expression they use. We have a legal team. Ask them, why do you require a legal team in your corporate sector or industrial sector? They say, sir, we can even think of doing without an administrative team. We can spare an administrative officer or a manager, but we can't think of sparing a legal team as well if we want to survive in the corporate or industrial world. Mr. Batra spoke about NCLT and NCLAT. Nobody would have heard about these tribunals maybe a couple of years back. But it has become one of the most, he is right, it's become one of the almost 75% of the litigation in the corporate world is going to be captured by the NCLTs and the NCLATs now. Because you don't have to go to the civil court, you don't have to go even to the commercial court. You need to approach only the NCLT and the NCLAT. To be or not to be is the question there. Well, in the ordinary civil court or in the commercial court, you fight for your financial issues. In the NCLT, in a fight between to be or not to be, you have faster solutions. That is one reason people go to, or rather this sector has taken a priority as far as dispute resolutions are concerned. So I'm sure this initiative taken by BW Legal has a lot of significance, a lot of relevance, because the world needs light. And light has a purpose of showcasing yourself and also helping others to see the world around you. And also, you need a lamp post as well, because people need directions. They don't know where to turn. So I'm sure that this global legal initiative of BEW will be really helpful to the corporate, legal and service sector as well, as to where to turn, when to turn, how to turn, why to turn. On all these 4 counts, you will find answers. And I'm sure this won't be another competition in the legal corporates, I believe. Already a lot of competition between national and international, but I have not found so much of a competition in the corporates within the country as well. Well, now just let me take maybe I'll be able to spare about 5 minutes if we want to some questions as well, because I have not found any good reason for speaking too much to a corporate world. When I addressed the Bombay Chamber of Commerce in their general body meeting also, I spoke about some legal services, and there are a lot of questions. So I realized that instead of my talking more on the enlightenment or illumination, rather I should also wait for the light the audience would like to have. So I may spare for about 5 minutes. But let's quickly take to the legal services. You know, the judicial system in India, we have the legislation who makes law, the executive who implements law, and of course the judiciary who says what law is. The role of judiciary is to say what the law is, and what the law should be is the role of the executive branch. We call it government, or the legislature, we call it either parliament or state legislature, as the case may be. State legislature legislates on the subjects which are allotted to them in the constitution, and the parliament, central union list, they legislate on the matters allotted to them, and there is a list list 3, where both can have the field, and unoccupied fields can be occupied by any one of them. But let's not go into that aspect, but I'm saying, just want to know what this legal service is. See, it's natural that in a society, there must be differences of opinion, disputes. So difference of opinion, the moment it takes the shape of a dispute, there needs to be a mechanism or an agency where a difference which has taken the shape of a dispute has to be resolved. So a dispute can be resolved in many ways. And the first and the best way known to everybody is take recourse to the court. Because court is a place where you agitate your grievances and get your grievances redressed or disputes resolved. That's the conventional place where we all know. Then came the tribunals. That is a substitution of the dispute resolution mechanism. From the ordinary courts, we wanted to put the resolution mechanism to fast track, and thus came the the tribunals. NCLT is like a tribunal, Community Law Board. The NCLAT, Appellate Tribunal. We have TDSAT, another tribunal. We have Electricity Appellate Tribunal. There are so many tribunals in this country. CAT, the Civil Services Tribunal. We have that service sector also. So there's ever so many tribunals, and the regime now is not in a mood to encourage many tribunals, and actually they are reducing the number of tribunals now. But that's a different sector altogether. But that is, the tribunalization was the second phase we examined, or rather we experimented as to for putting the resolution of disputes into fast track. Well, the society found even that is not working. So then they went to the third experiment of ADR, alternate dispute resolution. Alternate dispute resolution, according to me, is an additional dispute resolution mechanism as well. And in that alternate dispute resolution, we take things outside court and see whether we can resolve among ourselves, and then report to the court that we have resolved, now make it to your decree. So your job is lessened, your job is much eased out also. So that's how we came to this mode of arbitration. True arbitration was there from 1940 onwards, but it took its real phase of fast tracking when the international dispute resolutions were put into arbitration, and so many of the corporate disputes were also put to the resolution mode through arbitration. That's why in all the agreements you will find a clause now. In case of a dispute, it will be referred to arbitration, either a sole arbitrator or a panel of 3 arbitrators, one from each side, and a third arbitrator nominated from both of them, by both of them. He is called the presiding arbitrator. Earlier he was called umpire in the 1940 legislation. Now it is a third arbitrator. And this arbitration is almost like a trial. We find, from my experience as last 1 year, having done several arbitrations, I find this is a very good mechanism where we can find the parties putting for their case, and the tribunal making arbitral tribunal. We call it arbitral tribunal. Arbitrators make an endeavor to find where there is actual justice. It's not a truth-finding body. It's a justice-finding body as far as arbitration is concerned. Then there is mediation. You don't have to take so much of time for arbitration. You don't have to spend so much of money also in arbitration. You can go for mediation, where there's an experienced mediator. Well, I was trained by the Singapore International Mediation Center. So I found mediation is working quite well in Singapore. A lot of international and domestic corporate disputes are resolved through mediation there in Singapore. It's faster than arbitration and is less expensive than mediation and arbitration. Then we have this log adalat, and then we have this judicial settlement. These are the four methods, but as far as corporate sector is concerned, I will just concentrate on these two. Only one is arbitration, the other is mediation. Well, as an arbitrator and a trained mediator, my attempt has been to take this into a third phase, rather than a newer nuance of a mediated arbitration. In a couple of my arbitrations, I tried this mediated arbitration. Well, in the process of arbitration, I tried to see whether the parties can otherwise arrive at a reasonable settlement of the disputes. Well, under section 30 also of the Arbitration and Conciliation Act, also there is a provision that the tribunal shall promote conciliation of the disputes. And if they are otherwise willing to settle, a settlement award can be passed also. It is the force of a decree as well. Well, in one of the arbitrations I conducted, I asked the parties whether they are willing to go for mediation. They said, we are willing to go for mediation provided you are the mediator. I told them I can be an arbitrator and a mediator. They told them, no, but if you gave us your consent, we will give you word that we will agree on a solution under your mediation. We will go by your guidance and we will reach a settlement. A couple of disputes, I just want to put it short. Couple of disputes which came through arbitration have been settled like that, and the money they had to spend was 1/10 of the money which they would have otherwise spent in arbitration also. The sittings were less, and the resolution was faster, and the relationship was smoothened. Otherwise, in a litigation, one party wins, the other party loses. Whereas in a mediated settlement, there is a win-win situation where both parties have a satisfaction that we got justice. Otherwise, either in a court or in a tribunal or in an arbitration, one party always feels that I lost, or I lost partly, and the other party feels that I succeeded or I succeeded partly. Well, this feeling is taken away, and both parties have a feeling that there is a win-win situation. We have had a healthy and comfortable relationship as well. The greatest advantage of mediation or mediated arbitration in the corporate world is that you need each other. Because in a litigation, you don't actually take it to the final solution of somebody cutting away or your relationship. You need to continue. In the corporate world, the best principle and the first principle is that we need each other. If we need each other, it's not as if that, I will win and you will lose. We both have to win, and we both have to continue. So the continuance or continuing relationship, or rather strengthening of the relationship in a healthy manner, is what I found is more required in the corporate dispute resolution scenario. So I request all of you to think in those lines also. The moment a difference starts, you can think of a mediator. And mediation is actually a professional service. It's not a very unconventional service, conventional service. It's really unconventional, it's really professional as well. If you have the assistance of a trained mediator, then he will see whether the communication, how the communication broke, how the relationship can be restored, and what is the interest, what is the underlying interest, and what are the options, what are the alternatives, what is the legitimacy, and what is the commitment. On these 7 principles, a trained mediator will be in a position to help you to ease out your differences and come to a broader settlement of your disputes. And that way, the relationship continues, and you will grow to a healthier relationship in your corporate world as well. So this, in short, which I wanted to say in the keynote, I believe there is both key and note in this what I've said. Then I'll leave the floor open for maybe the rest of the 5 minutes.